Welcome to the fourth in Chiltern's series of podcasts entitled Think the Unthinkable. We call them that because we want to challenge people to think about things they probably would rather not. But it's only by addressing them now that future problems can be minimised at the most challenging of times. Today, we're going to dig a little deeper into the reasons to put a power of attorney in place for financial affairs. We're going to focus on married couples. Now, you might think if a married couple owns their assets jointly, then a power of attorney is less important because either one of them can deal with the finances. As we'll see, things are not quite so straightforward. I'm joined by Vince Whiteford. We're going to discuss the situation of a married couple, Billy and Jerry, who do not have powers of attorney in place. Billy loses mental capacity, leaving Jerry to deal with the finances. To start with, Vince, can't Jerry simply muddle through and carry on managing the household finances for both of them?
You'd think so, wouldn't you? If Billy has a stash of banknotes, then clearly Jerry can spend them in the shops. Jerry may know Billy's PIN number and passwords to make card purchases and perform online banking transactions. There may be pension or other income coming into Billy's account, with household bills being paid direct. So the situation may be one that can be managed, for a while at least. There can be problems though. Using someone's PINs and passwords isn't strictly legal. Jerry could be open to a legal challenge. Whilst that might seem unlikely, there's potentially a much bigger problem. We live in an age of scams and fraudsters. If a credit card or bank account is compromised when a card and its PIN number or bank access details are in someone else's hands, the protections offered by the law could be lost completely. The credit card company or bank could wash its hands of the problem. So, cutting corners on purely pragmatic grounds could be catastrophic. If the bank finds out about the incapacity, it's likely to freeze the account. Jerry will then lose access to perhaps the only source of cash.
Surely the solution is to have a joint account which both of them can access.
Sadly not. If there's no power of attorney in place, the bank can freeze the joint account entirely as soon as it realises Billy has lost capacity. This could be a serious problem if they run all their finances through a joint account and have no independent sources of income. The bank holds all the cards. It could freeze all transactions or perhaps just restrict expenditure to essential items only. At best, this is only a short-term solution for Jerry. It would prevent discretionary expenditure such as holidays or a new car. The banking industry has issued some guidance on this. As ever, the banking industry looks after its own. The guidance neither deals with all situations, nor is it readily available to the public. So no one really knows how they're going to behave in any particular circumstance, and this will still be at their discretion. But Jerry could be faced with spending long hours dealing with an automated online service or trying to find a real person in one of the increasingly scarce bank branches.
So, what happens if the bank accounts get frozen?
There has to be an application to the Court of Protection to appoint Jerry as Billy's deputy. This could give Jerry the legal authority needed to manage the accounts. But the process takes time, perhaps months, costs money, and inevitably causes stress. In the meantime, Jerry may have no means of support.
Ouch. Is the same true of other jointly owned assets, like property and investments?
Yes, the same principle applies. Until there's an attorney or court-appointed deputy who can act, Jerry won't be able to control these assets. There's a particular quirk when it comes to property. A deputy generally has very similar powers to an attorney, but not when it comes to selling jointly owned property. So with Jerry appointed as deputy, to manage the joint bank account and investment portfolio, if there's then a need to sell the family home, there may be a requirement for a second specific court application. That's more time, costs, and grief.
What's the answer then?
Well, the only real solution is for Billy and Jerry to have powers of attorney, appointing one another as attorneys before incapacity arises. It's simply not possible to execute a power of attorney once incapacity has been established. A power of attorney gives immediate legal authority to manage the financial affairs and will be recognised by the bank and other financial services providers. It also means Jerry can sell property without unnecessary time, cost, and stress.
That makes sense. Going back to something we discussed earlier, is it a good idea to have a joint bank account?
Yes and no. With the power of attorney in place, the bank should be happy to let Jerry continue managing the joint account without delay or interruption. It also lets Jerry manage any individual bank accounts Billy has. In practice, there can be a short delay while the bank completes identity checks and issues new bank cards for Billy's own accounts. That shouldn't be necessary for a joint account, which may result in less disruption when incapacity strikes. What may be worth considering is splitting the joint account and managing the finances separately.
Why is that?
Well, Jerry will have to keep accounts if any of Billy's personal money is being spent, and have to avoid conflicts of interest. Remember, an attorney or deputy should only be spending Billy's money on Billy's needs, not on other people, including Jerry's needs. If there's a joint account, how does Jerry demonstrate Billy's money is being spent properly? Splitting the joint account into two individual accounts to identify which money belongs to whom deals with this particular problem.
I've heard this could have a knock-on impact on care costs if Billy goes into a care home. Is that right?
The area of care home costs is fraught with complications. Each situation is different. I'll give a simple example. The basic rule is you have to pay your own care costs if you have a little over £23,000 in savings and assets. Usually this ignores your main residence if your spouse is living in it. Below £23,000, the local authority may contribute some or all of the costs. Your local authority normally assumes you own 50% of any joint assets, unless a different split can be demonstrated. So, in our example, if the couple has more than £46,000 in a joint account, they may have to pay all of the care costs for one of them until the balance goes below £46,000. In other words, Jerry's share of the joint account could get used to pay Billy's care costs. If the money's held individually rather than jointly to begin with, this can be avoided. As I say, it's a complicated subject and a moving target with government and local authority practice. Care costs are inherently very high and ever increasing. They can easily swallow even quite substantial savings. People should always take proper advice before committing to care costs.
You're making joint accounts sound more trouble than they're worth.
That's not the intention. They're obviously very convenient when both spouses have mental capacity because each can access the account in a flexible way. Some couples are fortunate enough not to have to worry about local authority funding for care costs. That makes life a lot simpler. An advantage of joint accounts is that if one spouse dies, the whole joint account becomes immediately owned by the other spouse. There are no delays with wills or probate. Joint accounts are one of the key areas where planning for powers of attorney diverges from planning for wills. So, there are pros and cons to joint accounts. Each couple needs to think about what's best for their own circumstances.
Is there anything else you'd like to add before we wind up?
Yes, this discussion isn't meant to scare people off having joint accounts, but rather to reinforce the need for married couples to have powers of attorney in place. They shouldn't assume they can get by without them. The main objective is to avoid the cost and inconvenience of applying to the Court of Protection to appoint a deputy, and in the meantime, having problems paying the bills. But there's a more fundamental reason. The beauty of a power of attorney is that the donor gets to choose the attorneys and specify who should act as a replacement if an original attorney can't act any longer, and can give instructions and guidance about how the attorneys should behave. If, on the other hand, there's no power of attorney and the court appoints a deputy, then, to state the obvious, the person who's lost mental capacity has no control over who it is. You could end up with someone you would never have chosen yourself. The court may appoint your spouse, but could appoint somebody else if it thinks your spouse isn't able to manage complicated financial affairs. There may be children who want to have a say. I know of cases where the local authority has approached the Court of Protection and appointed a deputy, and a complete stranger turns up. It can be a lawyer or accountant who can write their own checks at the donor's expense. So the message is, don't leave it to chance. Get powers of attorney sorted whilst you can. Finally, don't just complete the power of attorney forms online. Before starting to complete them, think about the issues raised in this podcast and work out what you would want if the unthinkable happens and you lose capacity to manage your own affairs. Take the time to think deeply about this, and remember, if the unexpected can happen, it often does.